And we will close the door once some more of these people arrive, because I know it gets cold. But there's coffee in the back. If you need to use the restroom, you just head right through this door, and it's on your left. Yeah, I'm not real good with left and right. We're a large group. I think the room will be full, but a friendly group. So if you have questions, feel free to raise your hand. If you're wondering about something, then chances are somebody else is too. So I'm happy to. I'll also stay after. So if there's something that you want to just note down and we can talk about afterwards, that's fine too. Hopefully everyone got the materials. There's also an evaluation form if you don't mind filling that out and being really generous at the end of the program. But hopefully everybody got the materials. This is just sort of a overview snapshot of all of the things that happened that relate to employment law over the past year. We're not going to talk about every single thing that's in here, okay, because there's just not enough minutes in the day. But I would certainly encourage you to read through this, because you can learn a tremendous amount from the mistakes that everybody else has made, okay? And every single company name that's in here under these cases is a regular business, just like you guys are, just like I am, just trying to, sort of muddle through California law and make a profit. And they end up on the backside of a lawsuit, oftentimes because of something that they didn't even realize they were doing that was wrong. Or they're doing something and they're 99% right, but there's one little piece that doesn't, fall into place. So you can really learn from what they did. If you think about, really, a lot of these lawsuits, especially when you're talking about harassment issues or wage and hour issues, it costs anywhere from, $100,000 to $300,000 to defend one of those claims. Okay, and a lot of these suits have been appealed multiple times. So, the little answer you're getting in here in this little, 2-inch paragraph is something that somebody paid a whole lot of money for. Okay, so it's almost like free legal advice. So I would encourage you to read it, or if you have insomnia, you could just parse right through it and, yeah, go right to sleep. But the way I organize the materials, I do a section in the front that talks about the legislative changes, and what I mean by that, these are new statutes, new regulations, new things that came from the legislative side. And then the second half and the bulk of the material is all case law stuff, and this is the stuff that we see out of the courts. And that has the same weight and effect as the statutory stuff. This is all stuff you're going to be bound by and held to. So that's why I like to spend a lot of attention on that kind of stuff, because this is the stuff that falls through the cracks. You may not realize that something that was perfectly legitimate, 2 months ago has now been deemed illegal by some court, and all of a sudden, if you're doing that exact same thing, you can get in trouble for it. So I want to spend a fair amount of time on those cases. They're organized by topic, so if there's a case that dealt with hiring issues or termination or whatever, that's how they're organized. And again, this isn't everything that happened, but it's the sort of most critical stuff, I think, that affects most employers. So I'm going to start with the legislative piece, and the first one, obviously, I want to talk about is that paid sick leave, AB 1522. And I'm going to spend a few minutes on this, but we're actually also going to do a seminar on the 26th of February that just spends a full hour parsing through what this new law means and where the little landmines are and how you can get tripped up. Like all of our new laws that we get, there are some sort of gray areas, and there's some critical information that's missing, and there are ways that you can get tripped up. So we are going to do a whole session on that, and if you're interested in attending that, just let Kelsey know. So just to give you an overview of what that paid sick leave law says, okay, I want to do an overview, and then I want to talk about a few key issues that I'm getting questions from employers and areas where I see you can get in trouble. In terms of overview, the law basically says if you're an employer in California, you have to provide every employee who has worked at least 30 days with paid sick leave. Okay, and the amount of paid sick leave that you have to provide them with is up to 24 hours in a 12-month period, a calendar year, or however you want to define that. Okay. So every employee, okay, your temp employees, okay, your, whatever, your part-time employees, your exempt employees, every employee, okay, your really crummy, horrible employees that don't ever show up anyway, okay, every employee in your place. If they've worked there for 30 days, then they are entitled to paid sick leave, all right? There are two different ways you can give them that 24 hours, Okay, the first way, and the way that I like better, and I'll kind of explain that a little more later, but the way I like better is this front load option. And the front load option says basically on this date, maybe we'll pick January 1 or maybe we'll pick July 1, but on this particular date, we're going to give you your full 24 hours. Okay, we're going to load up your sick leave bank. You've got your 24 hours, and then you can use them over the course of 12 months. When they're gone, they're gone. Okay, and when we roll back around to that trigger date, okay, the 12 months has expired, you get another 24 hours. Okay, so if that person ends that year and they still have 8 hours in their sick leave bank at the start of the new year, okay, we give them another 24 hours. If they have 0 in their sick leave bank, we give them 24 hours, and they just have that 24. If they have 24 hours in their sick leave bank, nothing changes, and they still have 24. Okay, that's the front load option. I like that a lot better. I think it's easier, it's cleaner. You don't have to worry about carryover. You don't have to worry about caps that don't match what they can use and things like that. So that's one way, the front load. And I have some clients that are opting to start that front load January 1 of this year. I have others that are going to wait until July 1 when the law actually says we have to start giving that sick leave. And that's really just sort of a business decision as to what's going to work better for you. I have other clients that are going to do it based on the hire date. Okay, on your hire date, we're going to front load this. You can't use it for 30 days, but it's in your bank, and then every year on your anniversary, you'll get another 24 hours or 3 days, whatever. Okay, so that's the front load option. The other option is the accrual option. Okay, and under the accrual plan, for every 30 hours that the employee works, they're going to accrue 1 hour of paid sick leave. So we have a bank that starts filling up as they work, okay, and then they can use it based on what they've got in their bank. Okay, if you use that accrual option, they will allow you to cap off their accrual at 48 hours. Okay, so they can only accrue up to 48 hours. When they hit that 48-hour mark and that's what's in their bank, they don't accrue anything else if you put a cap in place. Okay, you can still limit what they can use in a 12-month period, though, to 24 hours. And this is why I really don't like this option, because you have an employee who's going to be looking at their wage statement. Oh, well, look, I've got 48 hours in my sick leave bank, but they're only allowed to use 24. I think it creates confusion. I think it's unclear as to why we have this bigger bank than what I can use and so forth. You also have an issue of carryover, because you have to carry that time over if you're using the accrual method. Okay, so, but there are some, reasons maybe why you would want to do that. If you've already got a PTO or a sick leave plan in place and it's got an accrual, system, then that might be a reason why you would go with that method. So regardless of how you give it, whether you give it as a front load or you give it on an accrual basis, there are some things you can do with this. You can limit the employee's ability to take paid sick leave until they've been there for at least 90 days. Okay. What else do you need to do? Well, I'm going to back up a little bit. So everyone's focused on this July 1 date. There's 2 effective dates with this statute, and the January 1 date seems to have been forgotten a little bit. Okay, but what the law basically says, as of July 1st, that's when the paid sick leave needs to go to the employees. Okay, but as of January 1st, there are some other things you need to be doing. You need to have the poster up. There's a new Cal Chamber poster, and it has a big section about paid sick leave. Okay, so that needs to be up and posted in your workplace. There's also what we call the wage theft notice. Okay, and a couple years ago, Labor Commissioner said, whenever you hire somebody, you've got to give them this notice, and it says who our workers' comp carrier is, and what their regular rate of pay is, and what their overtime rate is, and blah, 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 all this information. We give that to the new hire when they're first hired. They've revised that notice, and going forward as of January 1 of this year, you have to give the new notice, okay, to all new hires, and there's this big section in there that says, okay, now you're entitled to paid sick leave, and blah, 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 blah. Okay. I have a lot of employers who are having problems because they may not be sure how exactly they're going to do the paid sick leave. Are they going to do accrual? Are they going to do front load? Are they going to revamp their existing policy so that it aligns and dovetails with these new requirements? And if you're not real sure, it's hard to give a notice to somebody that says this is what your paid sick leave is going to be and this is how it's going to accrue and all that. I would recommend that you give them, if you're still not sure how it's going to work, give them the notice that tells them you will be entitled to pay sick leave at no less than 24 hours in a 12-month period, blah, blah, blah. Okay. You can then supplement that and give them something more generous, and once you decide how the plan's going to work in your business, you might want to reissue that. It's still an open question as to whether or not your current employees need to get that wage notice, okay? Certainly for new hires, the law requires that. The labor commissioner will probably tell you, yeah, you should give it to everybody, okay? But the law doesn't actually say that. So, you know, from my standpoint, I like to just err on the side of caution, okay? Because I don't want to do anything to ever end up on the radar screen of the labor commissioner, okay? So I think it's probably safer to just send that out to everybody, but you don't necessarily have to. Okay, yeah?
Does vacation count towards the paid time off?
Yeah. Yeah, well, and then the question for the people who are streaming, does vacation count for the paid time off? What the law says is if you've already got whether it's a paid time off or a sick leave or a vacation plan in place, and it provides at least the same level of protection and rights that this new law provides, then that will be fine. That's one of the things, though, I want to hit on, because there are a lot of ways that this law kind of tweaks what most people are already providing, and so you will probably need to revisit that plan. But yes, if you're already providing, you know, paid sick leave, as long as it's at least in the same amount as this. Where people get tripped up, though, I'll jump ahead a little bit. Where people get tripped up is if I've got a paid sick leave plan and they accrue it and they get 5 days a year. Okay, great. Well, maybe my accrual rate is 1 hour for every 40 hours worked instead of 1 hour for every 30 hours worked. Okay, so over the long haul, I'm going to provide more days, but they're going to accrue them slower or more slowly, and so that may be a problem. And the reason they did that sort of speed up on accrual is they want those banks to build up so that the employees have the time available to use. Okay, so that's something to look at. So we've got to do the posting, we've got to do the notice. The other piece that this law requires, and this is as of July 1, is that the wage statement needs to have a line on it that says, this is your paid sick leave bank, this is what you've used, this is what you have left. Okay, so you want to make sure you talk to, if you do your payroll in-house, that you make that change, or that you talk to your payroll provider so that that's an item. You know, the wage statement stuff, if you look at Labor Code 226, it outlines, you know, the 9 different things that have to be on that itemized wage statement. Okay, and this is a new one, so now we've got 10 things that need to be on that wage statement. All right, wage statements are one of the #1 ways to end up in a class action lawsuit, okay? Because if there's something missing on that wage statement for one employee, okay, it's going to be missing for every single other employee, all right? And that's a perfect sort of setting for a class action lawsuit. So really make sure we make that adjustment.
The notice that we're giving is the same number as the
It's like 2810.5 or something.
same one we're giving, but an updated one?
Yes, there's an updated one. The updated notice, I can send it to you. If you don't have it, I can send it to you, or you can get it from the Labor Commissioner's website, which is www.dir.ca.gov. And if you just type in, like, I think wage theft notice, be careful, because 2 or 3 will pop up. There was the initial one that was proposed. There's the one that they have been using for 2 years, and then there's a new one. Make sure on the bottom it says revised 2014, or I think it's 2014 it says, not 2015. So make sure that it's got that revision. And you'll see it. If you look through the form, it's like a 2-page form. There's a big paragraph of paid sick leave. Okay, so that's the form you want to be using for that wage theft. Okay, so a couple of the things that sort of issues I'm seeing for, or ways to get in trouble. Okay, one of them is, like I mentioned, if you've got an existing plan and you're trying to use that plan in lieu of putting in some new paid sick leave program, the law it requires some different things, and one of the things is what they can take paid sick leave for. Okay, in California, historically, we've had, if you provide sick leave, we've got this kin care statute. And the kin care statute said an employee, if you give sick leave, and you didn't have to, but if you do, you have to allow the employee to use up to half of that sick leave for kin care, to care for their family. Okay, under this law, there's no half requirement. They can use all of it for kin care. Okay, in addition, family, okay, has taken on a new meaning. Family used to be kids and parents and registered domestic partners and, you know, kids of registered domestic partners, whatever, spouse, all that kind of stuff. But now under this law, we've added grandparents, we've added grandchildren, siblings, You know, arguably, I think the grandparents of the registered domestic partner or a spouse would also probably qualify. So it's a broader definition of when they can use it. Okay. They also say that you have to allow paid sick leave if it's for psychological or psychiatric care, if someone's been the victim of domestic violence or sexual assault and stalking, all this kind of stuff. So a little bit broader. Okay. The other thing that I think is going to get people tripped up is the rate of pay. Okay. So most of you have policies, oh, we pay out sick leave at the employee's regular rate of pay. Okay, great. You know, if you've got an employee who makes $10 an hour and that's all they ever make and the rate never changes, then that's their rate of pay. Perfect. Okay. But if you've got an employee who, you know, works on a prevailing wage job and makes this much, and then works at the regular, you know, work site and makes this much, and then is traveling and gets the travel rate, okay, and they're getting these multiple wage rates, how do we determine the regular rate of pay? Okay, and that's not a new question. We've had that question that comes up for overtime purposes, because of course overtime is paid at the employee's regular rate of pay. And when someone has multiple wage rates, we do this formula. It's called the weighted average, and we mush all that time together and divide by how many hours they worked, and that's our weighted average, and that's how we pay overtime. Okay, that's a sort of tried and true practice. Hopefully you guys are doing that if you have people with multiple wage rates. Under this law, they say, well, when somebody's making multiple wage rates, we're going to do a 90-day look back. Over that 90-day period, every payroll period that fell in there, take total compensation, not counting overtime pay, but total compensation divided by total hours worked, and that's their regular rate of pay. That's the rate that we need to pay paid sick leave out at. Okay, this is a brand new, you know, totally out of nowhere formula. Okay, so even if your existing plan complies in terms of accrual rate, in terms of family definition, in terms of everything else, I suspect it probably does not comply in terms of how the rate that you're paying that time out at. Okay, so that's something you're going to want to make sure you adjust, that we account for when we start actually paying this stuff out. Okay. And, you know, and don't think for 1 second that when you give somebody 24 hours of paid sick leave that they aren't going to use 24 hours of paid sick leave, okay? Because they are, all right? And that's always been the debate in terms of whether or not you provide vacation and sick leave versus just PTO. And a lot of my clients say, well, when I give them sick leave, guess what? They're sick. Yeah, you know, if it's just PTO, that, you know, we don't have that problem. But, yeah.
One more question.
Sure.
In the legislation, are employees allowed to gift to another employee their sick leave?
And the question for people streaming, can you gift my paid sick leave to somebody else? The legislation doesn't address that, I don't believe. I didn't see anything about that. I can go through the history to see if that came up as a discussion point. But that's certainly, you know, if you already have a policy where we allow gifting, that's certainly something that you could consider. I mean, I think that's a benefit to the employee. But I don't think that it requires that you agree to that. Okay. One of the things, when I talk about legislative history, if you look through the statute, you know, there are some things that are, you know, conspicuous in their absence, okay? And the number one thing is the employer's right to get a doctor's note or a medical certification, okay? If you have somebody who's out for 3 days, I have a lot of clients that say after 3 days, you need to give us a doctor's note, you know. Well, they discussed that when this bill was on the floor and they're deciding how much time and what we're going to do and what the language is going to be. And they talked about, can the employer ask for a doctor's note? And the debate went back and forth, and they ultimately decided to pull all of that language out of the statute. Okay, so there's nothing in here that says you, employer, are allowed to ask for a doctor's note. Okay, I think that when you put that discussion with the fact that they pulled all that language out, it suggests that you are not allowed to ask for a doctor's note. Okay, just because you can't do it necessarily under this paid sick leave, there are other times, obviously, when you can ask for the doctor's note. If we're talking about time that might be covered by the Family Medical Leave Act, the FMLA, or the California Family Rights Act, the CFRA, you know, or perhaps the, you know, Americans with Disabilities Act, whatever, or it's a workers' comp issue. There are other times when you can get that, but just be careful if you're trying to attach that right to a doctor's note to this one. Yeah.
For our employees, like after they're out for 3 days, we have to send them to CDO to get tested again. Would we still be able to do that in this case?
I believe so. And then the question is, you know, can we still send people, if they've been gone for 3 days, you know, we send them out for you know, testing. And I think that that's fine. I think really that's where that 3-day cap came from. I think they didn't want to go beyond 3 days because a lot of people have that situation where, you know, that's going to trigger a whole bunch of other requirements. So yeah, I think that would be fine. Okay, so those are the things to think about. Again, we're going to do another seminar that focuses entirely on this aspect, but just to have in mind, make sure you have your postings up and you're using the right forms, and that you're really thinking about how you're going to put this into place come July 1. Okay, because as soon as we have a new law, we have new lawsuits. So this, I suspect, will be a popular one. Yeah. Well, the question is there an advance notice requirement? And this is how we're going to do it. The only advance notice that's required is that wage theft notice, that this is how it's going to be done, and that's just for the new hires. I think probably you're going to want to let all of your employees know. Certainly, once it kicks in, they're going to get notice because it's going to be on the wage statement. Okay, so that would, I guess, technically be their notice. But no, there's nothing else that you have to disclose to the employees. It's on the posting. And so when they see that posting, they understand, because everyone's at the water cooler reading the Cal Chamber poster every day. You know how that goes. But that, in theory, that's their notice. Okay, so I'm on page 3. The next one I want to talk about is this abusive conduct. Okay, and this is, classic California law. Okay, where they tell you when you're doing sexual harassment training, okay, which is that AB 1825 training. Everybody with more than 50 employees needs to train their supervisors every 2 years or within 6 months of promotion, specifically with regard to anti-sexual harassment training. Okay, and so this law says, hey, when you do that training, you need to make sure you address abusive and bullying conduct. Okay, they define, this is like verbal abuse, derogatory remarks, insults, whatever. It's also sabotaging someone else or undermining their work, okay? And so you have to include that in the training, all right? The amazing thing about this, though, is, being mean at work, bullying someone, in and of itself is not illegal in California, okay? It has to be tied to a protected characteristic. You have to be bullying someone because of their gender or their race or their religion or their sex or their sexual orientation or one of those characteristics, okay? Just bullying someone because, I'm a jerk is not really against the law, okay? So here you have to, the law says you have to train your employees to not do something that's not even illegal. I'm like, okay, all right, whatever. This is California. This is how things go. We have to do all sorts of weird things. And actually, what the most amazing thing about sexual harassment training at all is, Arnold Schwarzenegger got into office and literally the second after he gets into office, he signs off on, sexual harassment training for all of us, okay, while he's fathering a child with his employee. So there you go. But at any rate, you're going to want to make sure, okay, if you're doing your sexual harassment training in-house, that you include that as a piece of that training, okay? If you have a handbook, then in your handbook, there should be a section that deals with harassment. That's one of the required provisions that has to be in a handbook if you have one. You're going to want to, make sure we include that language. It also includes abusive conduct, bullying, and so forth. Okay. Hopefully you're not bullying your employees anyway. It's not a good idea. But I just thought this was kind of crazy. The last thing I'll say about harassment is the law says you're supposed to train your supervisors, okay? And that's great. But you really, truly should train all of your employees, okay? And not just because I get paid to do training. But those employees can all get you into trouble, okay? And that training can be a really great tool in curtailing bad behavior, but it also can be an arrow in your quiver when you get hauled in on a harassment suit where you can say, look, we take this really seriously. We trained everybody in the entire company. We're really trying to be proactive about, stamping out this kind of behavior, and then it's not appropriate. So it really is a good idea to do for everybody. Okay, so below that we had sort of a specific requirement for farm labor contractors. They have to provide sort of a particularized training. That's an industry that typically has seen a lot of harassment complaints. So if you've got, that's kind of big for, I've got a lot of ag clients. The one below that, AB 1360, this just clarifies that when someone's taking that recovery period under the heat illness regulations, I'm out working in the sun and I'm overheated, okay, and I stop for 5, 10, 15 minutes, whatever it is, to cool down. That's all paid time. You don't get to deduct that time. It's not a change in the law. It just clarifies, what that law requires. We had a change beginning of last year with respect to that heat illness stuff, and that is that if somebody says I need to cool down and they're denied the ability to have that cool down period, okay, in addition to like a potential OSHA violation, everything else, you're also going to owe an additional penalty of 1 hour of pay at the regular rate of pay. Okay, so be careful with that. They take the heat illness stuff really seriously. And there are new regulations that the DIR is working on that will probably come out middle of this year. So we'll look for those. But make sure that they're getting paid for those breaks. And, and if you really think about this, I haven't seen anyone do this, but they just need to tell you, hey, I need a cool down period. I'm overheated. And you don't get to say no, and you have to pay them for that time. And they get to take as much time until they cool down. So in theory, they could show up for work, really hot, yeah, and just go sit down all day. I mean, I haven't seen that happen, but based on the language of the law, I guess they could really do that. Okay, I'm going to skip down to AB 1660, which is this driver's license piece. I'm getting a lot of questions about that. And what this law basically says, in California, we had a law that said, okay, the DMV can issue a driver's license to somebody who's not documented, okay, and on that driver's license, it'll say, right at the top, undocumented, okay, but it's a valid driver's license. They're able to actually drive around even though they're not documented, okay. So I've got employers that have somebody, hey, you're going to, get assigned to the trucking side here. We need a driver's license. The person shows a driver's license. Oh, you're undocumented. Well, wait a minute. Can you even work here? Are you eligible to be employed? Because you're not a documented worker. Okay? And what the law says is if somebody shows you that card, okay, for the purposes of satisfying, the driving requirements so that you can ensure that they're licensed and are a valid driver, okay, you can only use that license for that purpose. I don't get to take that license, march down the hall to HR and say, you better pull their Social Security card and their passport and all their documentation. Okay, I don't get to use it for that purpose. I can only use it for the license, for the driving.
That document be used as I-9 verification as one document?
Well, you're raising another question. Okay, so the question when we talk about I-9, can we use that driver's license? If somebody hands you a driver's license and a Social Security card and the driver's license says undocumented, that's not going to be valid. That's not on its face going to be valid to support their ability to work. Okay, they need to come back with something else. But those are separate inquiries. If I say, okay, you're coming to work, let me see your documents, that are required for the I-9 form, and they give me documents, and I look at them, and they look valid on their face, okay, great. I put that away, I'm done. I've satisfied my duty in terms of the I-9. I've looked at it, it's not written in crayon, it's not like cut out with scissors, okay, this is a real, what looks like a real Social Security card, then I've satisfied that. Now, oh, you're also going to be driving, hand me your driver's license, oh, okay. I don't get to put those two pieces together, all right? You still have to ask for that employment eligibility documentation, you just don't get to consider the word undocumented on the driver's license when you make that determination.
Even if they're giving you the driver's license as part of their right to work?
Well, when they give you that, you say, well, this document doesn't satisfy that. Can you give me something else?
But you can't use that to report them or
Correct. You can't use that. And the other piece of this law is it says, look, when you find out that information, when you see the driver's license, oh, you're undocumented, you have to treat that information as private and confidential. You don't get to disclose it to anyone. You don't get to call INS. That's private, separate. You just pretend like you didn't know it. Okay? You only get to ask for the driver's license, remember, if driving, if it's required for the job. Okay, I don't get to when the receptionist comes in, oh, you're going to drive to work? Let me see your driver's license. Okay, it's only if driving is a piece of that job or if a valid license is part of the, sort of regulatory requirements for that position. All right. It's kind of akin to the medical marijuana registry cards. We had a few years ago the Compassionate Use Act, which allows people to use medical marijuana if they, hurt their back or something, whatever, I don't know. So they get a prescription and they go and register, and then they get this registry card. If the employee comes in and shows you, hey, I'm registered under compassionate use and I can get high all weekend, okay, the employer doesn't get to say, what, you're a stoner, you're fired. Okay, they don't get to make any kind of employment decisions based on that card. Okay, it's the same kind of thing here. You know, you can still have a drug policy that says, you know, you don't get to be high at work, or you don't get to, you know, come up positive on a drug screen. Okay, but that's separate. If I terminate somebody because they show up positive on my drug test, I'm terminating them because they're violating that policy. I'm not, it has nothing to do with whether they're registered or not registered, or hurt their back, or are a stoner or aren't, or whatever. This is my zero tolerance policy, and that's what I'm enforcing. Okay, so it's sort of the same kind of mindset. We don't get to take action based on that undocumented word on the driver's license. Okay, on the next page, page 4, AB 1443, okay, unpaid interns and volunteers. Okay, you used to be able to harass them, I guess, all that you wanted. They're now protected under the Fair Employment and Housing Act. Okay, remember, anytime somebody becomes protected, okay, they become a potential plaintiff. So this is the whole new world of people that can sue you. But hopefully you're not, you know, abusing your interns. Be really careful with interns too. They're getting a lot of scrutiny because you know, we kind of relaxed the regulations on who can qualify as an intern. You know, as soon as we do that, everyone's like, great, I'm firing all my employees and bring on a bunch of unpaid interns because this is a real cost saver. They're really sort of, you know, hampering down on that. Make sure there really truly is a benefit to the person who's working as an intern, whether it's a, you know, school credit or some other thing. Hey, they get to work with fun people and they get some great experience. That's not going to be enough to have somebody qualify as an intern. Okay. I think, let me see, I'm going to skip. I mean, the rest of these are all sort of self-explanatory, and they're not too earth-shattering. On page 6, AB 10, just remember we're going to have another minimum wage increase that will kick in January 1 of next year. Okay, whenever minimum wage goes up, of course, there's a ripple effect into a bunch of other areas because your exempt people need to be making typically 2 times the minimum wage, okay, in terms of their salary in order to be exempt. There are some of the commission people need to make 1.5, but you know, that's going to impact other payment obligations. Split shift pay, and it's an additional hour at no less than minimum wage. So all of those payments get triggered by that minimum wage rate. So just keep that in mind, that that's coming up. Down at the bottom, the home health care workers, under federal law, you know, they took out you're going to all of a sudden start getting overtime if you're this in-home caregiver. And the Department of Labor basically said, look, we're not going to start enforcing that until July of 2015. So even though that law has kicked in on the federal side, there's not going to be any enforcement action taken. It's not quite as helpful for us in California because the California law already changed, and you do have to provide overtime under state law. But for those of you who are exempt from the state side, that's kind of helpful. Okay, so that kind of wraps up the legislative piece. Are there questions about any of that stuff? And again, I'm happy to stay after, but I do want to get into the cases because this is usually the more fun stuff. Although, God, you know, I look for funny cases or interesting stuff, and it was really kind of a, you know, dull year in terms of the case law. So sorry about that, but yeah, I don't get to select the funniness of the cases. Unfortunately, they just get filed. Okay, so this first one, that Antelope Valley, this is a really, and every time I do the update, I spend, you know, 10 minutes telling you, be careful with independent contractors, be very, 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 very careful. Okay, this case gives you a really good snapshot of how a court is going to analyze that independent contractor versus employee question. Okay, and in California we have what's called the right to control test, and what the courts will look at is, you know, how much control does the employer or alleged employer exercise over the manner and means in which the work is done. Okay, are they scheduling them? Are they telling them how it's done? Are they reviewing them? Are they, you know, approving time off? All that kind of stuff. And they look at all those different aspects of that relationship that you have with this worker. Okay, the less control you have, the more likely they are to be an independent contractor. The more control, the more likely they are to be an employee. And this court really sort of parsed through that, you know, whether the work is part of what you regularly do. How long is the work assignment? Do they provide their own tools? How are they being paid? Do they have their own business? They really march through those questions in sort of a nice way. So it's a good, if you're having that question, that's a good case to look at in terms of how that question is going to get resolved. Knowing how they're going to analyze something is one thing. Okay, but these cases are extremely fact-specific, and that the case right below it is a good example of that, okay, because here they are independent contractors at the trial level, okay, it goes up on appeal, oh, no, they're employees, okay, this stuff can really kind of turn on a dime, all right? So you really want to take an honest look at the situation. I mean, I know when you're analyzing this, you're like, come on, please be an independent contractor, please, please, okay? Don't let that bias sway your analysis, okay? My shorthand test is down there. I mean, really, if it looks like a duck, walks like a duck, quacks like a duck, okay, the court will not tell you it's a chicken. It is a duck, okay? It doesn't matter when that person cries and says, oh, please, I want to be 1099, you know, I don't care if they tattoo independent contractor on their forehead or sign in blood, whatever. If that relationship is such that you're exercising control over them, it is going to be deemed an employment relationship, okay? And when you mess up on independent contractors, okay, it's very, very, very expensive because, you know, not only is that something where you can really get hit with a class action, you're misclassifying a huge group of people if you've got more than one, but also you've got somebody now who didn't get wage statements, who didn't get, you know, you don't have time records for, you don't have meal and rest periods for, you don't have, you know, overtime payments for. I mean, there's a huge number of statutes that are going to get triggered. You didn't pay payroll taxes. I mean, you can get in trouble from sort of every vantage. All right, so it gets very, very, very costly. You know, not to mention that if you willfully and knowingly classify someone as an independent contractor when you know or should know that they're an employee, okay, you can get hit with these huge fines, up to $10,000, $25,000, you know, per violation. Okay, so there are areas in the law, you know, there's what you have to do legally, okay, then there's the practical reality of I'm trying to do business and not, you know, be bankrupt, okay, and at some point you balance I'm willing to assume a little bit of risk over here even though there might be some exposure, and you sort of balance those two, okay. Independent contractor is not the place where you want to accept some exposure and some liability. The risk is huge, okay, so I would always err on the side of caution with that one. There seems to be, actually, if you go to the next page, there's kind of a trend that I'm seeing in the courts in terms of drivers. If you have drivers, you know, FedEx got hit with a suit, UPS got hit with a suit, this is Affinity Logistics. There seems to be a trend that drivers are employees rather than independent contractors. Okay, that's where a lot of those cases had won at the trial level and are now moving up the courts, and they're saying, sorry, they're employees. So if you've got drivers, that's just something to keep in mind. Okay, if you've got them classified as independent contractors, it doesn't mean you're necessarily going to get a lawsuit. It doesn't mean that you're incorrect. Just you want to take the time to review that. That's worth looking at. Okay. Solis v. Sierra Chemical was an interesting case, especially for us, I think, in the Central Valley. But so the guy goes to work and gives a fake Social Security number and works for a little while. I mean, it looked valid on his face, whatever. They didn't know. And so then he gets discriminated against, or says he's being discriminated against, and files a lawsuit. And there's a doctrine that we have in the law called unclean hands. And what unclean hands says is basically, you know, you don't get to march into court, plaintiff, and complain about something that somebody did to you if you're also doing something bad. Okay? It's kind of like you know, what comes around goes around. That's not fair. You're getting what's coming to you. You know, there's a joke actually that, you know, everything that we have in the law you could have just learned on the playground, okay? Because a lot of our legal doctrines, you know, harken back to this sort of playground justice. You know, the statute of limitations is you snooze, you lose. You know, and so unclean hands is, you know, oh yeah, what comes around goes around. And so historically that has been a pretty successful defense. If you've got a plaintiff that's doing something really bad, well, they don't get to march in and complain about something else. So the employer used that argument here and said, look, you know, he may or may not have been discriminated against, but he wasn't even authorized to work there in the first place. He gave us fake documentation, and so he doesn't now get to sue for protections under the Fair Employment and Housing Act. Okay? Sounds like a reasonable argument, but the court said, nope, we don't care about that. Every worker in your you know, employ that is in your company, okay, is protected by that Fair Employment and Housing Act, okay, whether they're authorized and allowed to be there or not. So his lawsuit was able to proceed. Okay, it's the same kind of thing with workers' comp. You know, if somebody comes in and, you know, shucks, they gave you fake documentation and they slip and fall, okay, that's still going to be covered by workers' comp, even if they weren't supposed to be there or authorized to be there. So be careful with that one. I still don't think, and the question came up, I did an update yesterday, the question came up, are you better off than to use E-Verify or double check those social security numbers and make sure. I still don't think that you should. You may have to. If you're a federal contractor, you have to use the E-Verify system. Okay? If you're not, then you don't need to do that. I think if somebody gives you the documentation, it looks good, great, put it away. You've satisfied your burden. I don't want you to be on notice that there are issues with that social security number. Okay? You're going to have to protect them anyway. They're going to be in your workplace, and you're going to have to comply with the Fair Employment and Housing Act already. So I don't think there's a huge benefit to checking that stuff. It can trigger additional notice requirements and other things you need to do in order to help that person, correct whatever mistake, if it's a number that's switched or whatever. So I would not encourage you to do that. Sometimes it's better to just bury your head in the sand. Okay, so that's pretty much it for hiring and independent contractors. Anybody have questions? Okay, let's move to wage and hour. I'm on page 11. So the first one I want to talk about is this Cochran v. Schwanz. Okay, and this is one of the cases, hasn't gotten a lot of press, but this is, I think, one of the cases that could potentially be one of the biggest cases we had this year. And we'll see. I suspect that it will get appealed, and hopefully it'll get hemmed in a little bit. But basically, the argument here was there's a Labor Code section 2802 that says, look, when an employee incurs expense in the course of doing their job, okay, the employer has to reimburse them. All right, so if I go to OfficeMax and pick up all the paper for the copying, I get to come back. The employer has to pay me for that. Okay, if I'm using my car to drive to OfficeMax, they have to pay me for the use of that car. Okay, and that's pretty standard. Everyone's been sort of doing this. Well, in this case, the plaintiff said, hey, my employer calls me on my personal cell phone, and I'm required to use my personal cell phone in the course of doing my job. Okay, so and I'm not getting reimbursed for that cell phone use. And the employer said, well, we're not reimbursing you because he was on a family plan. There was no actual cost. He had his phone and he paid, whatever, $30 a month or whatever. It was unlimited calls. Okay. The other piece was he wasn't actually even paying it. It was like a family plan, so he was the second phone that comes free or whatever under some family plan. So there was no actual expense to the employee. Okay. And so the employer's argument was, well, we reimburse for expenses. We don't reimburse for things that don't actually cost the employee anything. All right. And the court said, no, we don't look at expense as the amount the employee has to pay out. We look at expense as the benefit that the employer gets. Okay, the employer is getting a benefit from the employee having that phone. Doesn't matter who pays the bill, doesn't matter if it's free, doesn't matter if it's unlimited texting, doesn't matter if it's, he's on a 2-year plan where they don't charge him, whatever. None of that matters. What matters is the employer is getting a benefit on the back of the employee. Because of that, reasonable reimbursement is required. Okay, so the problem with this case, okay, it leaves a whole bunch of areas wide open, because if we don't have to have an actual expense to the employee, then there's a whole bunch of other things where the employer is getting a benefit. They have a landline and you're able to call the employee on their home phone. Maybe do they have to be reimbursed for a portion of that? Or they're emailing you from home and they have internet service and Wi-Fi. Is that something we have to reimburse? I mean, it's really potential. There's potential for this to get way out of control in terms of what you have to reimburse. The other thing is they didn't tell you, how much you have to reimburse them. Okay, they say reasonable. Well, reasonable minds can differ in terms of how much you have to give somebody for the use of their phone, particularly when it doesn't cost them anything. Okay, so there's a lot of questions that are open. When he says he was required to use his phone, well, what does required mean? Does that mean the supervisor called him once on the phone? Or does that mean it was in the handbook, you have to carry your phone at all times? At some point you cross over a threshold where the employee has this expectation that they have to do this. But that's really, who knows when that happens. So there's a bunch of stuff that's really wide open with this case. It's one to watch. The takeaway for now, okay, if you have employees that are using personal devices, okay, you're going to want to make sure you're providing at least some kind of allowance for the use of that, whether it's a laptop or an iPad or a tablet or a phone or whatever the case may be. I get the question all the time of, are we better off to provide a company phone that I give to my new employee when I hire them, or am I better off to give a cell phone allowance, and then they use their own stuff? Okay, I think depending on how this case plays out, we're probably going to be better off to give a company cell phone. Okay, I like that anyway because you retain control over it. Okay, you know, when you start sending naked pictures to everyone and a harassment suit comes in, I want to be able to go get that phone. Oh, look what you're doing. Okay, and have access to that. If it's your personal phone, you know, I have a lot less ability to go and grab that and get that because you have more of a privacy interest. Yeah, Joyce.
Well, we give phones to most of the employees that need them. However, a lot of them have a better phone than what we give them, so they prefer to use their phone, or they transfer the calls from our phone
To their phone. Yeah. I think, you know, that's in that gray area. The question was, you know, what if you give them a phone and it's this, you know, 1980s, you know, giant, you know, whatever, and they transfer all those calls to their brand new, you know, 6 Plus because they want to use that phone. I think as long as if it's something that is within the employee's control, I think you maybe have a better argument. But again, you know, that's a gray area. I don't know how they would analyze that. I mean, are you getting a benefit from that upgraded because they're responding faster and they can also email from there and they can, you know, send you documents and they can, you know, I mean, arguably. I think you could take this case out to the nth degree, you know, of, you know, anybody comes in and provides anything that's their own, you know, equipment or tools or whatever. At some point, you may need to reimburse them for that. Yeah.
We do issue, our management staff, we all have iPhones and we're required to carry them at all times.
Okay.
Even in the building, because our building is quite large, but we have hourly employees that also have flip phones, which
Okay.
obviously nobody wants a flip phone.
Yeah.
But it's for company use only.
Okay.
And they've been instructed that that phone is not to be used for personal use.
Okay.
Because we know everybody has a better phone.
Yeah.
But also, they're required to leave those phones at their desk.
Okay.
In a locked drawer, should be, when they leave at night, because I've instructed supervisors, you should not be calling
Yes.
hourly people after hours. That phone is only while
They're at work.
medical assistance. So if a
Yeah.
physician needs to call them or they need to be reached, that's why we provide it. But I've given our supervisors explicit instructions, like don't call them on it after hours.
Yeah.
You shouldn't be calling them. You should be calling them on a personal cell.
Yes.
Because we should be paying them for that time. And you know,
Well, and that's a great policy and plan, because the problem you have when you start giving these hourly people a phone, you know, all of a sudden they're making calls and checking email and doing stuff during the off time. So it all of a sudden triggers a bunch of overtime. They can come back, well, look, they didn't, you know, pay me for this hour and whatever. So yeah, I think that's a great policy. And I think you're pretty safe. I mean, this is, you know, just one decision. We'll see how it plays out. I think as long as you are either giving them a phone and actually paying for it, you know, or giving them the option to, you know, here's what you can use, or you're giving them an allowance, you know, and it's not like $1 a month, it's not some nominal amount, but it's some, you know, regular amount. You know, I don't know what the, you know, $50 a month, maybe $100 a month. You know, I have a lot of employers that say, well, I'll pay 50% of the bill, whatever the bill is, things like that. As long as you're giving them some sum as an allowance, I think you're probably going to be okay. But this is just something to keep in mind because, you know, if you've got people that you know, I tell you, hey, you're going to go on light duty, I'm going to let you telecommute for 6 months. Well, while they're telecommuting, okay, there's internet you're benefiting from, there's, you know, whatever, phone lines you're benefiting from, all that kind of stuff. It's just something to keep in mind, okay, that sort of hadn't really been on the radar screen till now. Okay, down at the bottom, High-End Be Safeway. This is why we care about little things like, does the person get enough for their cell phone allowance? Okay, so this was an overtime violation. The guy recovered $26,000 in unpaid overtime, which is not a tremendous sum. When we talk about the wage and hour cases, typically it's a lot more because you go back 3 years and there's all sorts of penalties. He recovers $26,000, okay, and then he gets his attorney's fees of $603,000, okay? So this is why this stuff matters. Even if your violation is small, which oftentimes it isn't, because you can tack on so many other employees. But even when it's small, okay, it's very, very, very expensive, you know. So we do want to pay attention to this stuff. You don't want to be the one that ends up paying this stuff out, okay. I read that case and I was like, oh my God, I work for the wrong law firm, that's for sure. It's time to up my rates, I think. The second bullet down, integrity staffing. This is the first sort of court decision we have that dealt with the screening cases. And I've been talking about those for, at the updates a little while. And what I mean by screening cases, this is, you work in a retail store, and at the end of your shift, you open up your bag so that, the Apple supervisor knows you don't have 8 laptops in there or an iPad or something that you're stealing. Okay, and they look in your bag, and then you're free to go. Okay, and the argument has been, hey, I clock out in the break room, and then I walk to the front of the store, then I have to open my bag, and maybe I have to wait behind 2 or 3 other employees, and so maybe it takes 5 minutes or 10 minutes to get my bag checked, and none of that time from when I clocked out until I am actually cleared to leave is being compensated. And this is, hours work that's being missed, and so forth. Okay, so Apple was the first one to get hit. This was actually Amazon that made it up quicker into the courts. And what the court looked at was, do we need to compensate for that, whatever chunk of time at the end of the shift? And the court said no. Under the Fair Labor Standards Act, which is the federal law that talks about wages on the federal side, you do not need to compensate that because they found that the actual screening thing is not linked to the principal function that the employee was hired to do. Okay, this is just sort of a secondary thing, so we don't need to compensate that time. Good case, okay, for those of us that are covered only by federal law, all right. I think we need to wait and see how this stuff is going to play out in California. I don't like to make predictions, but I bet it's going to be a different result under state law, okay. In California, we have this doctrine of de minimis time that's so small that we can't really capture it for payroll purposes. We don't have to pay. You don't have to cover that, okay. And what they mean by de minimis time is, seconds, a minute, upwards of 5 minutes, if it happens consistently day after day, is probably not going to be de minimis time. So, this is, I'm walking through the parking lot, hey, did the fax come through? Yeah, okay, I don't have to run back in and clock back in because I answered the question about the fax. That would be de minimis time. So we'll see how these cases shake out in state court, but that's just something to be mindful of. I did this update about 2 weeks ago for the SHRM chapter, and 2 different people came up afterwards and said, I work at a retail store, and we have to check out, and it takes 10 to 15 minutes every day because the supervisor is helping a customer or something comes up or whatever. So, if that's your operation and that's the reality of how things play out, pay them an extra 15 minutes at the end of their shift. That is far cheaper than, paying $700,000 in attorney's fees down the road. So, okay. Bottom of page, were there any questions? No. All right, bottom of page 12, Peabody v. Time Warner. I touched on this last time, but this is a case that's really worth reviewing again. One of the biggest cases, if you've got anybody who's being paid on a commission basis, okay, this is a really critical case. What they said, basically, well, in this case, the employer had a commission plan. Person's paid twice a month, okay? And they had a commission plan, and the commissions were paid at the end of the month. So we look at the month, great, 8 sales came in, here's your commission, we pay it out at the end of the month, okay? And that was the commission agreement. It was all in writing, super, okay, it's awesome, all right? The employee came back and sued and said, look, they say I'm exempt under the commission sales exemption. The commission sales exemption requires that the person be paid 1.5 times minimum wage, okay, for all their hours worked, whatever, no less than that, okay, in order to be exempt under that exemption. And if they are exempt, they're not entitled to overtime. And the person's argument was, well, my first check of the month, there's no commissions paid in there, and I'm making, $10 an hour about, okay. My second check of the month, when all the commissions come in, yeah, I'm making 8 times minimum wage, but, I'm not really exempt in the first payroll period. And so the question was, and the employer said, well, no, the commission covers that entire month. So when we pay the commission in the second pay period, we look at it over the course of the month. In the course of that month, did the person make more than 1.5 times minimum wage for all hours that they worked? Okay, and that historically had been how things operated. All right, and the court said, no, the commission will only apply to that pay period in which it's paid. Okay, so the person was not exempt because the first paycheck, they did not make 1.5 times minimum wage because they weren't, exempt, overtime was owed, and blah, blah, blah. Okay, so the lesson, you're paying people on a commission basis, make sure that commission piece lines up with your payroll periods. Okay, we don't get to allocate that back over time. Or make sure that your employees are, making enough that it satisfies that 1.5 times minimum wage. Although, the wrinkle there is that they need to make at least 50% of their, money from commissions as opposed to from wages. So, that may also create a problem. But if you've got commission people, just make sure those line up, all right? Because that's a bummer. On the next page, page 14, under pending cases, and I'll tell you, this is the absolute least satisfying thing about putting together this update. I mean, it takes a long time to read through all these cases and, synthesize them all and write them all out. And then, as soon as it's off the presses, it's out of date, okay, because some decision gets decided. Yeah. So Mendiola is a case that was decided about a week ago, okay, and this is the California Supreme Court. And what they were looking at was the sleep time deduction. If you've got somebody who works a 24-hour shift, historically we've been able to deduct 8 hours of pay from that shift if the person's provided with an opportunity to take, at least 5 hours of uninterrupted sleep and blah, 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 okay, and they have a place that they could sleep and all this kind of stuff. And that had been sanctioned by the labor commissioner. That's how it's been done for years and years and years. Okay, and here comes the California Supreme Court saying no. If they are subject to the control of the employer, okay, those hours are going to count as hours worked. All right, I haven't read through all of the dicta and everything from that decision. That's just sort of the headline of it. It's certainly something that we'll cover in the summer update because I think that'll be one of the biggest cases we have for 2015. But just something to keep in mind if you have people on a 24-hour shift. They just got a lot more expensive. Okay, page 15, there's not much there. Adam Sandler's nanny said she was a slave. I thought that was kind of funny. I'm like, well, I have 3 kids. She is a slave. I can come in as an expert witness on that one. Page 16, I'm going to skip past this. This is employee benefits. Of course, the big issue here is the Affordable Care Act. We've done a bunch of seminars on that, and if I get into affordable care, we'll never actually get out of here. So I'm going to move ahead to page 17. We're on leave of absence issues. And the first one I want to talk about is that Escriba v. Foster Farms. Okay, this was a really good case for the employer. And basically what happened, the woman comes in and says, hey, my mom needs surgery, and I need to take some time off to go and take care of her. So the employer says, great. We have this beautiful FMLA form, and this is a condition that might qualify you for leave, and blah, blah, blah. Okay, and they give her all this documentation about FMLA. She's eligible for FMLA. She has it available. And she says, no, I don't actually want to use my FMLA for this. Can I please just get an unpaid leave of absence that doesn't count against my FMLA time? Okay, and the employer did not have to agree to that, but no good deed goes unpunished. Employer says, sure, we'll give you an unpaid leave of absence. You have this much time. You need to be back on X date. Okay, so here comes X date. She doesn't come back. And they say, hey, you need to be back. She doesn't come back, doesn't come back, doesn't come back. Okay, she comes back like a week later, I think. And they say, sorry, you violated our 3-day no-show, no-call policy. This was not an approved absence, and you're fired. Okay, and she then files her lawsuit. And she says, look, you can't fire me for taking leave that would have been protected. Okay, she had not exhausted a full 12 weeks. This was something that she could have taken leave for and been allowed to take. And the employer said, this is not protected because you told us you didn't want this to be FMLA leave. All right, and the court agreed with the employer. They said she does not get to, sue under the protection of a law that she said she didn't want to have apply to her. Okay, it helped for that employer, okay, that they had it all in writing. I am voluntarily electing to not use FMLA for this because, she wanted to keep that time. I think she knew down the road, somebody's going to have a baby or someone's going to be sick. She was going to need that time later on, so she wanted to preserve it. But she affirmatively, disavowed her protection under that law, and that was enough. Okay, so if you have somebody who comes in, doesn't want to, burn any of their leave, make sure you get it in writing if you want to authorize that. Of course, just word of caution, that was the Federal Family and Medical Leave Act, okay? Maybe under the California Family Rights Act, okay, which is sort of the state counterpart to FMLA, that wouldn't be okay. I don't know. That has not yet been decided, but certainly there are a lot of other areas where state law is far more protective. I don't know if you can waive that right under state law at this point, but But you certainly can under federal law, you know. I think actually there's probably a pretty good argument that the analysis would be the same under the CFRA. Okay, it just has not been blessed by a court at this point. So the other option, of course, and they come in and they say, I don't want to burn any of my leave. You say, sorry, our policy is when you go out on FMLA, you're out on FMLA, and this is time, we're designating it. It's you have the right as the employer to designate that time, so long as it qualifies. Okay, so, and that's probably a safer option. RIA v. General Atomics, which is down at the bottom of 17, this was a case where the person's exempt, okay, and they want to take some leave, okay, and they take leave in 2-hour increments, and the employer tried to deduct that from their leave bank, okay, and there's been this sort of, it's funny, the labor commissioner about, I don't know, 8 years ago or something, issued an opinion letter that says when an exempt employee takes leave, you know, is absent in an increment of 4 hours or more, you can deduct from their leave banks. Okay? And for whatever reason, you know, this opinion letter just went into long-term memory for every single employer. Okay? And everybody has that 4-hour mark. Oh, it was less than, you know, it was less than 4 hours, so I can't deduct from the leave bank. Okay? And when so what happens? You know, if it's less than 4 hours, we don't deduct. So guess how long everyone's absent for? You know, 3 hours and 59 minutes. Okay? Now we can't deduct from the leave bank. The labor commissioner ultimately pulled that letter back and issued a new letter that said you can deduct from leave banks as long as, you know, if the person's gone. It doesn't have to be greater than 4 hours. Okay, and that's what this court basically agreed with. All right, the guidance that comes from the labor commissioner, you know, has some sort of persuasive authority, but it's not precedential. It's not something that the courts have to follow. It's just a guideline. I like to go by what the labor commissioner says because typically your claim is going to start at the labor commissioner's office, and that's how they're going to review it and analyze it. You know, so it's maybe going to cost you something to defend that practice if you're going to disagree with the labor commissioner, even if they're wrong. Okay. In this case, the court said no, that's fine. If you've got an exempt employee, you have a bona fide plan in place, okay, and they're gone for 2 hours or 1 hour, you can deduct from that leave plan. Vacation, sick, PTO, whatever. Okay. One thing to be careful though, a bona fide plan has historically been read to be a plan that allows for at least 5 days of leave in a calendar year. Okay, so you talk about when I say we're going to do that seminar on paid sick leave, you know, if you've got a plan under the paid sick leave law that allows for 3 days, is that going to qualify as a bona fide plan under, you know, these kind of deduction requirements? I don't know. That's one of where these laws start intersecting and you see conflict and real contradiction. That's where you can get in trouble. At any rate, we're not talking about deducting from pay. I'm not taking anything from their wages. Their salary is exactly the same, but on their little line item of vacation, oh, guess what? You had 28 hours and now you have 26. Or you had 28, now you have 27. Okay, I can deduct from that. All right, and that's okay. On the next page, White v. County of Los Angeles. And this looked at a fitness for duty exam when someone returns from FMLA. Okay, so the person's been out, they had a serious health condition that qualified. They now say, here's my, you know, doctor's note, I'm released to come back, great, I feel so much better, and I want to go to work. Okay, and you as the employer think, not real sure if this person can come back to work. I'm not real sure if they, you know, and I've had this come up for a lot of clients, you know. The guy is like drooling and hunched over, you know, and they're like, well, are you sure you're better? You know, you don't look better. What can you do? What can you do in that situation? Are you bound by that release that the employee has provided, or can you actually send them out? And this court said you can, you know, if it's job related, consistent with business necessity, you can send that person out for a fitness for duty exam when they return from FMLA if you have a reason to believe that they may not be able to actually do the job. Okay? You want to tie it to that job though, okay? I don't think this is a open-ended spectrum of everybody who comes back, well, you better go do a fitness for duty if you want to come back. Okay, the facts of this case were very sort of slanted for the court to get to that decision because she was an investigator for the DA's office, and so she's carrying a gun, okay, and she goes out for psychological reasons. You know, she goes nuts, okay. So then, you know, 2 weeks later, she's like, oh yeah, I'm not crazy anymore. Give me my AK-47. I'm ready to go. I mean, of course, the employer was a little concerned, and I think that's what dictated that result more so than this open-ended carte blanche for employers to require that fitness for duty. You know, if your receptionist comes back and says, okay, I'm ready to go, I can sit at the desk again, and you say, oh, you better go get a fitness for duty, I mean, I think that may not fly. You know, unless maybe she carries a gun. Okay, I guess that's the other thing. You can give your receptionist a loaded weapon. Anyway, make sure when we have those things, and this is a good lesson in any time you can link something you're requiring the employee to do with health and safety. Okay, particularly workplace safety. It's a very, sort of protected area zone. You get a lot more leeway. Okay, from the employer standpoint, because obviously we have all these shootings and things like that. Okay, if there's no more questions about leave of absence, I'm going to move to social media. And this first one is a really interesting case. I'm really curious to see how this plays out. So the guy works for one company. It's a sales thing. And while he works for them, he builds up his LinkedIn contacts and all of his sales leads and whatever. And then he quits and goes to work for another sales company and takes his LinkedIn account and all those contacts and starts contacting these people for somebody else. And the employer comes back and sues and says, hey, that's our customer list. He friended and friend requested everybody on our customer list and then took our customer list somewhere else. Okay, and that's a trade secret, and that's a trade secret violation. And the court didn't say, I was really shocked. I thought they would say, sorry, it's his LinkedIn, forget it. But the court, they analyzed it instead of, how protected was this information? Did they really guard it internally? Is this a list of people that's difficult to compile and hard to maintain? Is this something they keep separate and private? And if so, then it's arguably a trade secret. It's not automatically going to be a trade secret just because it's your customer list. But if you protect that information, then that's something you may be able to hang on to. Okay, and that could be really useful if you've got people, that are migrating from one company to another, that they can't take all that information. So I thought they'd come down the other way. So it's an interesting case. LinkedIn presents a whole bunch of different issues. One of them, I think we'll get to in a little bit. We have the first case that's proceeding on whether or not a LinkedIn reference is something that would trigger the Fair Credit and Reporting Act disclosure requirements. When you get a consumer report on someone that talks about where you get feedback from people that know them and references and all this kind of stuff, there are certain disclosure and notice requirements you have to comply with. And there's a lot of them. You have to tell them you're going to look at it. You have to tell them when you get it. You have to tell them that you might take action. You have to tell them you did take action. And there's 100 steps, versus going on LinkedIn and, oh, here are these 18 other people that work with them. And, oh, yeah, oh, they endorsed him for this. Oh, this is a trusted reference. Oh, I've worked with them. I mean, it's really amazing the amount of information that's just getting, poured out. Probably most of you in your handbooks have a section that say, employee references. No one's allowed to give any information about former employees, except for the head of HR, and we'll only tell them the dates of employment, and we won't tell. Okay, that's what the labor code requires. Except for the 19 other people that work with them may have just told everything that happened in their course of employment on LinkedIn. Oh, you moved. Oh my gosh. Oh, you're back better from your workers' comp thing. I mean, there's just tons of stuff out there. Okay, so I think LinkedIn is one that's really going to trigger a lot of claims. At any rate, if you've got your whole set of customers and you tell everybody to import that into their Outlook contacts, okay, that's something you might want to think about in terms of protecting it. Have them set up a separate account for that or somewhere way that you can safeguard that so you can protect that information. On page 20, this was a kind of, oh yeah, do you have a question? Yeah. Pardon?
A question about this LinkedIn.
Yeah.
Where you state here that the employee downloaded the information, but you don't necessarily have to download anything. It just exists.
Yeah.
So if the salesperson was terminated and was to leave, can the employer take that information?
Well, that's the thing. In this case, he did. They had a list, and he took that list and actually imported it in. Yeah.
He's developing it
As he's going along, I think you.
going along.
Yeah, I think you have less of a claim there, obviously. But if you've got, if I've got these salespeople and I want them to be contacted, obviously I want them to be doing sales, and I say, here's our list of potential contacts or potential leads, have them imported into a separate LinkedIn account that's just for that, or a separate Outlook account, or a separate place so that you maintain the, you know, control over that or the ownership of that. As soon as I start letting them take little bits and pieces, you know, away, it becomes, you know, more likely that it's theirs. Yeah. And I think that's when I really thought the case would go the other way. I thought that employee would be able to say, sorry, this is my LinkedIn. You know, and that kind of goes back again to, do you want them to have their phone or your phone? Because I've got a policy that this is my phone, and everything on that phone is mine. I'm the employer, I own the phone, I pay the bill, it's mine. Okay, so when they go to leave, oh, you've put all of your LinkedIn people on it. Well, guess what? Those are my contacts. You know, I like that, but you have a better argument of keeping that data. So, but yeah, there's the intersection between what belongs to the employee and what belongs to the employer is just really muddled when you start throwing in the technology and the capability and where information is stored. You know, the cloud, does the cloud belong to the employee or the employer? You know, I don't know. But some lawyer is going to get paid a whole bunch of money to figure that out, I suppose, at some point. You just don't want to have to foot the bill for that. Yeah.
The way Edward Jones does it is you have to open up a LinkedIn business page. It's the same with Facebook. I can't use my personal Facebook.
Yeah.
The Facebook business
Yes.
page. So that if you're in HR and you want them to use LinkedIn, say, hey, fine, but you're going to use the business one.
Yes.
And then just know that that's the
And that's for business, and this is separate. And you can have you know, you can have 50 LinkedIn. I don't care, but for our stuff, our list, our contacts, it's going to go through this page. Yeah, I think that's a much better way to do that. And it's a lot more common because, you know, every so often you know, you say, oh, this is somebody I went to college with or something, and then they'll say, oh, not this account. Here, they direct you to a different one of like, this is my friend's or my personal one. So I think that is becoming a little more of an accepted practice. Okay, page 20, this purple communications. Okay, and this is, and we'll see how this plays out. This was a National Labor Relations Board ruling. Okay, so it doesn't have precedential effect in California or anything, but it's just something to watch. This is really the push of where the NLRB is going. And basically they said you cannot tell your employee, I know you mentioned earlier the cell phones, you're only allowed to use them for work-related purposes. You cannot tell your employees that they can only use email for work-related purposes. That's what the decision said. It said if you tell them it's only for work, then you're telling them they can't use it for unionizing purposes, and unionizing efforts and communications are protected under the National Labor Relations Act, and so ergo it's illegal. Okay? I think that's a really extreme view, but that's really the push that they're making. You see it with the social media policies that they shoot down of you can't restrict speech, you can't restrict an employee's ability to, you know, engage in concerted activity and all this kind of stuff. So this is one to watch. I don't know how successful that argument will be because, you know, it wasn't like it was a unanimous panel. You at least had one NLRB judge saying, yeah, that's not fair, that's not right. You know, I mean, and they never say that something's not right. So by the time you have at least, you know, somebody up there saying that's not good. But that's just one to keep in mind, okay, in terms of how you, if you do tell people, look, you can only use this for work-related purposes, you might want to put a little caveat, except that, you know, nothing contained in this policy infringes on your rights under Section 7A of the National Labor Relations Act, or some little, you know, disclaimer in there. Might be worth adding. But just something to be mindful of. Oh, Sunbelt at the bottom. This was one of my favorite cases. So the guy gets a company phone, and then he sets up his phone number, whatever. Okay, so then he quits and leaves or gets fired. I don't remember what happened, but he moves to a new company, and before he leaves, he turns in his phone. But he says, hey, you know, everybody knows this phone number. Can I take the phone number with me? And they say, sure. Okay, he goes and gets a new phone, sets up his new phone number on the new phone. Great. Okay, goes to the new job, and I think he was doing sales or something because he's getting these emails and leads and all sorts of information. Okay, and so every time he syncs his phone, unfortunately, he did not delete his Apple account on the old phone. So it syncs, and the old employer is like, oh, look, here are the 14 appointments he has, and here are all of his leads, and here are his new contacts, and oh, look, oh, here's his new marketing piece. I mean, all of this stuff, it shows up on this old phone. Okay, so the employer then starts, you know, using that. Oh, they're meeting at Tuesday at noon. Well, we'll meet Monday at 3. Okay, you know, so they start, you know, using all that information. He files a lawsuit and says that's not fair. They don't get to use this information. That's my private stuff. That's my phone. And they knew that this was private information. And the court said, sorry, you didn't delete it. It came to the employer. You know, it's just like anything else that the employer did not solicit this information, they absolutely can use it. You can't go back now and argue that it was private. Okay, so a couple lessons there. Okay, delete your Apple account if you're switching jobs, all right? But this is a good example of the difference in the analysis, or the difference in the leeway you get when the information just comes to you through no fault of your own. Oh, hey, somebody just happens to stumble into HR and show you a picture on Facebook of somebody at the Santa Monica Pier when they just called in sick. Okay, information that just comes to you that you have not asked for, have not solicited, have not tried to dig out and get, you have a lot more of an ability to use that versus the stuff that you're hunting around and trying to find. Okay, that looks like more like an invasion of privacy versus, hey, this just came to me and I'm allowed to act on it. Okay, I get that question all the time. Somebody's like, oh, I'm really sick, and then they check in at the Santa Monica Pier. Okay, so, and you can absolutely, call them out on that. That's fine. If this information comes to you, hey, we have reason to believe that you may not have been being truthful when you said you were sick. Okay, the fact that it's on somebody's Facebook page or LinkedIn or whatever is not necessarily going to insulate that information. Okay, page 21. That's that LinkedIn case I mentioned, the one with the Fair Credit Reporting Act. So just keep an eye out for those ones. I'm going to move to discrimination and harassment. If nobody has questions, any other questions about social media? Okay. The first one I want to talk about is this Caldera. Okay, and this is your absolute roadmap of what not to do. Okay, when somebody issues a complaint, person complained they'd been harassed, so the company goes, oh, okay, yeah, great. Then they promoted the alleged harasser so that they would be the direct supervisor of the alleged victim. Yeah. Okay, whoops, that's what we don't do. It's a good example, too, of where the employer doesn't get the benefit of the doubt in these kinds of cases. You need to have done something to show that you're taking this seriously. Maybe they did really think about it and consider it and do an internal investigation, but they didn't have anything to show that they had done that. They had no documentation. They didn't, and so the presumption is that they're doing something bad or that they're not taking it seriously. Okay, and that's why I say it's important to train everybody. Those are all things that you can use to show, look, we do not tolerate this behavior. You can't control what everybody does, okay? If you could, I would be out of a job, I suppose. But you can't control what everybody does, but what you can do is show these 10 things I've stacked up. This is what I'm doing to try and fix the problem. Okay, and if you're doing that, you're going to be in pretty good shape. It doesn't mean you're not ever going to get sued, okay, but you're not going to be a likely target. Okay, because when the demand letter comes in from the plaintiff's attorney, give us $50,000 because somebody grabbed somebody on one day in the back cloakroom, you can say, yeah, I'm not giving you anything because we're doing this person never complained, we have got a process, we've done investigations. Well, you're going to look a lot less attractive. Plaintiffs' lawyers don't want to go after the people that have all of those ducks in a row and that have done all that, but taken those steps. So you can fend off, sort of preemptively lawsuits that way. On page 23, this American Pacific, DFEH v. American Pacific, this is the sort of workplace counterpart to the school bathroom law we had last year. And that was the one in public schools where a person might be one sex biologically but identifies in a gender sense with the other sex. They're allowed to use the bathroom of whatever gender they identify with. Okay, it got a lot of press. It was sort of a big issue. That's the same thing in the workplace. Okay, if you've got somebody, and in this case, the employer had somebody who was going through a gender reassignment or a sex reassignment surgery thing, and they hadn't completed it all the way. Okay, and so they wanted to use the bathroom and locker room, of the sex they were going to be, not the sex that they currently were. And the employer said, nope, we base this on biology. And the court said, nope, you don't get to. Okay, they get to use whichever facility they identify with. Okay, and it was interesting because the question comes up, and I've had this come up before, where they say, well, we want to make this person feel comfortable. It's going through this change, whatever. But how about the feelings and the comfort level of everybody else who's in this locker room? There's a bunch of girls who are saying, yeah, I don't want to share a locker room with this guy. I know he's going to be a girl at some point, but right now he's a guy, and I don't want to have him in the locker room. Okay, and the court shot that down entirely and said that level of discomfort with change or with, allowing these people to be in the bathroom or whatever is the same level of discomfort that people had when, you know, minorities enter to the schools or the different workplaces, when women entered the workplace, you know. So that justification was not sufficient, you're fine, to justify, you know, keeping the person out, okay? The simple and easy answer, okay? I mean, I suppose if you've got locker rooms, that's one thing, but, you know, have a unisex bathroom. You know, have one bathroom. I don't care. Everybody can go in it, you know. X, Y, Z, both, okay? I really don't care. You have one bathroom, and then that solves that problem. You probably don't want to have locker rooms at work anyway, because that seems like, you know, a ripe ground for a harassment complaint. But anyway, that's what that case was. The next one, EEOC v. Walgreen. This was another case that is really interesting. I mean, if you just read that headline, disabled employee could not be terminated for theft. Okay, it will make you think that we live in a crazy world, which we kind of do. But the facts of this case really dictated what happened here. This was somebody who had worked, I think, what did they say, 13 years? No, she'd worked there for 18 years at Walgreens, and she was diabetic. Okay, and so one day she is at work and you know, her blood sugar goes high or low or whatever happens, and she needs to eat something. She goes and gets a bag of chips, costs $1.39, opens the bag of chips, eats it so that she feels better. Okay, great, now she feels better. She went over to the cashier. There was nobody at the cashier then, so she stuck the bag of chips there and, you know, left, forgot about it, never paid. Okay, and here comes the store manager. What? Someone was eating chips, they didn't pay for them. Okay, they figure out it was her, and she's fired. She's fired under their, this is what I love, their anti-grazing policy. Like, okay, so you can really, yeah, this is how they view their workers, I guess. So they have an anti-grazing policy, and they said you were grazing, okay, so you're fired. Okay, and she files her lawsuit and says, you know, this is ridiculous, okay? And of course, the court agrees with her. They say, no, you don't get to fire this person for the one occasion when her medical condition necessitated that she eat these chips, whatever. But what this case illustrates is the idea of these blanket policies. And their blanket policy was a legitimate business, you know, justified, great policy. And the policy, I mean, I don't like the name, anti-grazing, but the policy was, hey, the employees don't get to just eat the food and steal from us. That was the gist of the policy. You don't get to steal our products while you're working. Okay, that seems like a legitimate, fair, totally reasonable policy. Okay, and they still got in trouble for it. And the reason they got in trouble for that policy is if you have a policy like that you're just going to apply across the board without doing any kind of individualized assessment, that's where you're going to run into trouble. In this case, they said you need to look at the reasonableness of the policy, whether it's justified and legitimate, okay, but you also need to look at how applying that legitimate policy to this particular person, you know, plays out, and whether that's reasonable, whether that's fair, whether that's justified, legitimate, and all that stuff. Okay, so it's a two-part analysis. Where I see those blanket policies all the time is with, you know, absences. More than 6 absences in a year will be deemed to be excessive absences, and that will not be tolerated, will result in discipline, you know, up to and including termination. Okay, I don't like that policy at all. You know, if I've got 7 absences and I've got, you know, my kidneys failed, okay, guess what? I'm a disabled employee. You know, you don't get to just cut me off right at that 6th day, okay, without further discussions, that interactive dialogue. You know, I may be entitled to a whole bunch of other time off, you know. So be really, really careful with the blanket stuff, you know. Nobody is allowed to wear, you know, any logos, okay, on their clothes. You have to wear only whatever, our uniform, or only the store's logo, okay. The NLRB tells you, well, that's telling them they can't wear a union logo, okay. If you've got just this blanket policy, we draw the line right here and that's it, that's where you can maybe run into trouble. Okay, so that's the lesson from that one. Also, rename your policies if they reference grazing or like farm animals. Okay, that's your really important takeaway on that one. Okay, the Espinoza v. Spencer. This is another example of where the employer really doesn't get the benefit of the doubt when you're talking about harassment complaints if it looks like they're not doing anything. Okay, you had the management is one ethnicity, and then the supervisor is a different ethnicity, and then the people he's supervising are the same ethnicity as the management. Okay, and so supervisor complains about employees to the management, and they don't do anything. And he later comes back and is able to sue, saying, well, this is a racial clique. above me and below me are the same ethnicity, so obviously they're in cahoots, and that's why they didn't address this, that's why they didn't look into it. It's pretty, I think that's a sort of a tenuous argument, but the court said that's fine. That might be enough to show that there was, and it's because the employer didn't do anything. It's because they didn't address it. They couldn't show any kind of documentation, any kind of investigation, any kind of efforts that they did to stamp that out. Okay, so just be careful with that part. The USF one on the bottom, cow, I don't know if that's how you pronounce it, but this was a good case as to when you have to start that interactive dialogue process. And what I mean by interactive dialogue is if you have an employee who either is disabled or is perceived as being disabled, okay, it's the employer's obligation to begin an interactive dialogue. The interactive dialogue is to try to find out whether or not there's some reasonable accommodation that might make it so that employee could come back and perform their essential job duties. Okay, it's the employer's obligation typically to start the interactive dialogue, and then it's the employee's obligation to say, hey, maybe this would work. Hey, maybe that would work. Okay, I've got my, my foot's in a brace, but I'll be better in 2 weeks. Can I telecommute for 2 weeks? And they have to suggest stuff, and then you evaluate, well, that's reasonable or not reasonable or whatever. Okay, so that's what the law requires. In this case, he was a math professor, I think. So he's a math professor, and he's threatening all the workers, the TAs, and yelling and screaming, and he's really mean, and he's just, whatever, blows up. I think threatening behavior. Okay, so whatever. He's just not nice. And the employer says, hey, we want to send you out for a fitness for duty exam because it seems like maybe this position is not something you can do because it's making you incredibly agitated and really upset, and, you're wielding a knife at the secretary or whatever. Okay, and he says, nope, true to form, being the total jerk that he is, he will not go, he won't do anything the employer says, and he never does go for the fitness for duty, and they end up firing him. And he says, look, this was my mental state, this is part of a condition I have, it makes me angry and mad all the time, and they didn't start that interactive dialogue process with me. They fired me for it, it's linked to my disability, it's not fair. Okay, that was his lawsuit. And the court sided with the employer, and they said, look, if they had no notice that he's suffering from any kind of condition or disability, being mean isn't a disability yet, okay? So, that's, if you have some condition, employee, that you might need an accommodation for, you better be the one to let the employer know, okay? Being mean and being angry in and of itself was not enough to trigger that obligation for the employer. Okay, and they also said that, the fitness for duty was not any form of accommodation. It was for the employer to know that this person actually could do the job. Okay, and they found that it was job related enough and consistent with business necessity that they were, warranted in asking for that exam. Okay, so again, I think, he's threatening people at work, kind of linked in with workplace violence. I think you get a little more leeway with that stuff. Landucci v. State Farm. This is on page 25. Okay, just a reminder that age discrimination claims are really on the rise. Okay, so they're asking her, how old are you? Are you a baby boomer? When are you going to retire? Okay, that's, the old people don't like to hear that. They already know they're old, so let's not do that at work. Yeah, well, I'm right up there. I'm covered under the age protections now that I'm an old person, so they really don't like to hear it. I can tell you personally. Ludovico, or Kaiser, whatever, at the bottom. This is a great case. Well, it's a good analysis of hostile work environment claims. And I get that question all the time. Well, how do you know if something is, enough to create a hostile work environment? If somebody slaps you on the backside on your way into work, is that enough? And the standard for hostile work environment is that the conduct needs to be severe and pervasive, okay, such that it alters the conditions of employment. So what's sufficiently severe and what's sufficiently pervasive, it's sort of a gray area. You can think of it, though, like a sliding scale. The more severe something is, okay, the less pervasive it needs to be. Right? The more pervasive it is, the less severe it needs to be. I might get slapped on the backside and that's not real severe, but if it happens every single day, okay, then that might rise to the level. Okay, and I might get raped in the coat closet and it only happened once. Okay, it's not pervasive, but it's really severe. All right, and that would be enough. So this case looked at a situation, and there were all witnesses. When this thing happened, you know, there's 8 other employees there, and they all testify. It's not even contested as to whether or not this happened. The question was, is this single incident enough to be severe and pervasive? So it only happens one time, okay, so we know it's not really pervasive. And what happened was she's a nurse, and an x-ray tech walked by her and grabbed her, and she tried to get away, and he wouldn't let her go. And he said, I'm going to shove my tongue down your throat. And she said, you know, ugh, whatever. Anyway, and she didn't like that, or he's not cute, I don't know, whatever. Anyway, she said, she finally breaks away. Okay, he said some other comments too, but the tongue down the throat was the worst one. She finally breaks away, and he goes off on his way. And she says, this was really distressing, this was really upsetting. You know, obviously, that's not what you want your employees doing at work. Okay, so was that severe and pervasive enough? And the court said that is not severe enough to create a hostile work environment claim. Okay, it's a great case for employers, okay, especially where you've got sort of things that, you know, maybe aren't great. It was a dirty joke that was told, okay, but it's not that over-the-top bad. Okay, I don't want you to have the takeaway from this one to be, okay, you get to grope one person, you know, you get one bite at the apple, you know, go ahead, yeah, woo, one time, only once, you know, that's not going to work. That's not good, okay? You know, remember that courts are allowing in what's called Me Too evidence. So in this case, there was one single incident, okay? But very rarely do you have somebody who's harassing people that's only harassed one person one time, okay? And when the courts let in the Me Too, what that is, you know, this is the person who's suing, okay? But you have all these other people lined up. Guess what? He did it to me too, did it to me too, did it to me too, okay? And all of a sudden, when all that evidence comes in, something that was just the single incident all of a sudden becomes far more pervasive. Yeah, question? Oh, okay. Yeah, so anyway, just something to be mindful. It is a good case, but it's, I think, maybe going to be, I mean, I don't know how effective it will be for employers down the road. On the next page, 26, City of Delano. This is a person who complains about harassment and doesn't want to work with the person who's harassing her anymore, so they move her to a new job. And she says, look, the new job, I'm doing all these menial tasks. This is basically tantamount to a demotion. Okay, her pay didn't change, her benefits didn't change. They just gave her a new assignment. Okay, and I see this a lot. The court said that move in and of itself might be enough to create a claim that she was retaliated against or whatever. When you run into that situation, because I have a lot of clients where, you know, there's 2 people. You know, on this shift, okay, the alleged harasser and the alleged victim. So now what do? I either have to leave them together, where now there's going to be more harassment or alleged harassment, or I have to move somebody. Okay, it's always safer to move the alleged harasser. Okay? I've yet to see a case where the employer gets in trouble for trying to prevent harassment. But if the victim comes to you and says, I want out of the shipping department, I don't care, I want to not work with these people, I want out, I want out, I want out, okay? If your choice is you decide you're going to move them instead of the alleged harasser, make sure you get a writing statement from them. I understand I'm voluntarily electing to do this. I understand the company will move the X, Y, and Z people that I've complained about. I understand that I've been counseled and blah, blah, blah. Make sure you have something to show, no, I'm not doing this under duress. I'm not being forced to do this. This is something that I am voluntarily opting to do. Okay, it's not going to be airtight because they'll come back and say, well, they told me I had to sign that, okay? But as long as you at least have something to try and document that, you know, we weren't punishing her by moving her, we were accommodating her and, you know, doing this at her, you know, request, you'll be in better shape. Page 27, Taylor v. Neighbors Drilling. Okay, these are the cases. My office has probably, I don't know, 5 of these types of cases. This is male on male. They're both heterosexual harassment claim. Okay, and the claim is for hazing, teasing. You know, they shot him with, you know, an airsoft gun in the crotch. Okay, this is teasing and joking. It's the new guy. Okay, and that's what these claims are based on. So this guy, they called him a gay porn star and whatever. Okay, it was teasing, joking. And the employer tried to defend on the grounds that this is not sexual harassment because there's no sexual intent. There's no motivation. There's no desire. This is, you know, maybe bad language, okay, but it's not sexual, you know, in terms of somebody trying to, you know, sexually harass somebody or get something out of them. And the court said that doesn't matter, okay? Any conduct, whether it's of a sexual nature, that's in the workplace, can form the basis for a claim. We actually, they amended the Fair Employment and Housing Act last year to sort of include this, to codify that. You do not need sexual motivation, intent, or desire in order to maintain a sexual harassment claim. Okay, so what this picks up in, you know, I mean, I've got a lot of clients where it's, you know, haha, it's funny, good old boys, they're all, you know, out on a rig together and it's funny, or they're all, you know, in the shipping yard and yay, we joke and tease and we, you know, and they're friends and buddies. You know, we slap each other on the backside like they do in a football game or something. You know, that's the kind of stuff you want to watch for because that's where these claims are coming from. You know, I mean, I could totally understand. I'm born and raised in Bakersfield and from a family that was in the auto parts business for forever. Okay, I understand that mentality. It's just really, really risky at this point to do business that way. You know.
It's not bullying.
What?
But if they claim that under bullying?
Well, they could now claim it under bullying. Yeah, we didn't have bullying when this case went up, but yeah, they could certainly argue that that was bullying. The thing with bullying, though, is unless you link it to a particular characteristic, it's not really against the law. I can't go out tomorrow and file, you know, if I stood in this training and screamed at you at the top of my lungs, you couldn't file a complaint against me unless you could show I screamed at you because of your race or religion or gender or something else. So bullying in and of itself, you know, it's not good. You know, it might form the basis of a harassment claim of they're, you know, harassing me because of, you know, because I'm young or I'm the new kid or something. But in and of itself, yeah. All right, other questions? Okay. Weaving v. City of Hillsborough, under federal law, attention deficit and hyperactive disorder is not a disability. Okay, remember though, under state law, under federal law, the standard is you're substantially impaired in a major life activity. Okay, a major life activity, by the way, is like everything. It's walking and breathing and reading and sitting, okay. So, you know, arguing that it's not a major life activity will always be a loser. But under federal law, you need to be substantially impaired. Okay, under state law, you just need to be impaired. All right, so I suspect that ADHD might be a disability in California. On page 28, these are just some of the, oh, are the pages off?
No.
Oh, okay. They were off at another session, so hopefully you guys got the right version. One of the cases to watch is that Abercrombie, and this is sort of a follow-on. We had a case a year ago where the person wore a headscarf, and Abercrombie said, no, that's not part of our like super cool Abercrombie look, whatever. Anyway, and she filed her religious discrimination claim. Well, this is another one. It's going up now to the U.S. Supreme Court. This is somebody who came in and applied for a job and was wearing a headscarf, and they said, oh, you know, we can't hire you because you've got your headscarf on, and, you know, we don't wear head stuff at our stores. So we'll see where that one goes. I would all but guarantee you that they will tell you that you cannot disqualify someone based on that, you know, headscarf, okay? That you need to have a policy other than, you know, our customers aren't going to want you to wear a headscarf, okay? But we'll see how the court reacts to that one. In the news, that second bullet down, okay, this was the one funny suit. This is a New York company, okay, and they had their employees follow this belief system, what they called, the guy who owned the company, his aunt had created this thing. She called it Onion Head. But she was the Denali, like the spiritual leader for the company, and she would come in and they had to chant and they had to hold hands, and then after they had any interaction with their coworkers, they had to say, I love you. So, I mean, yeah, really, I know. You know, I mean, so, you know, where's that fax? I love you. Oh my gosh, it just makes me laugh to think about this. This second, do your employees love each other? It might be a problem. Anyway, so we'll see where that, I can't wait to watch that one play out. But anyway, yeah, you probably don't want to require people to say that they love each other at work. The people who complain too, so a girl complains and then they moved her desk, and they had this big like sort of cubicle area. They moved her desk right to the middle, so all the people had to walk around or whatever. And then they're all saying I love you to, you know, everybody else, but they would not say I love you to her because of course, you know, she, you know, I mean. And they took them on the case is just amazing. They took them on a spa, like a strategic retreat, but it was a spa weekend, and you were paired up with a coworker, and you had to be with your coworker at all times. So they had, like, you had a room, and then this is you and you had to go with this I mean, oh my gosh, it's just amazing, the stuff. Yeah, that's when you're like, okay, I hate to read most of these cases, but that one was really entertaining. Okay, so at the very bottom here, we have a brand new, highest amount that a single plaintiff has been able to recover. This was AutoZone. She went out and had a baby and then came back, and they were really mean to her. And so she got, I think, $870,000 in compensatory damages, and that her actual damages of lost wages or whatever they said. So and then in punitive damages, $185 million. Okay. Again, you know, this is not a class action. Okay. This isn't for every pregnant person that's ever been working in AutoZone. Okay. This is one plaintiff, one person. Okay. That will probably get reduced on appeal. Most of these big, huge judgments do, but you know, oh, woo, we only owe $60 million. Okay, well, you know, at some point, whatever. You know, you've already crossed that invisible line. I like to look at where those decisions come from. Previously, this is out of San Diego. Okay, so the cost of living and stuff is a little more expensive in San Diego. You're going to see higher verdict value down there. You know, San Francisco, same kind of thing. But previous to this, the highest one we'd had was in Sacramento. Okay, and that was, I think, 165. So, you know, it's not that it only happens in San Francisco or LA or San Diego. Okay, we've got even in the Central Valley where, you know, the value of money is a little different. Okay, we're still seeing those big judgments. You know, and that's scary because guess what? That's, you know, the Sacramento jury pool isn't that different from the Bakersfield and Kern County jury pool, okay, in terms of makeup and demographics. So, anyway, just something to be aware of. On page 30, we get into the whistleblower stuff, okay? The takeaway from all of the whistleblower cases is that the whistleblower protections are extremely broad, okay? And you need to be very, very careful if you've got somebody who is actually trying to blow a whistle. That Hagar, which is the third bullet point down, basically said you can have subsequent whistleblowers that are still going to be protected. And what I mean by subsequent, I mean the idea of whistleblowing is we want to encourage employees who know that something bad is happening, you know, to blow the whistle and sound the alarm. Hey, this is, you know, illegal and fraudulent. There's, you know, there's no smoke alarms, whatever. Okay, we want them to bring that information forward. Once they bring the information forward, okay, we know about it. The whistle's already been blown, okay? But, you know, this case was somebody comes along behind and says, hey, give me that whistle so I can blow it too. And then they give it to somebody else and somebody else. All of a sudden, each one of those subsequent whistleblowers, okay, is entitled to protection too. All right, so if you, from a practical standpoint, you know, you've got, OSHA comes in, you've got some big violation or some, you know, whatever, you got your guy over here you're going to fire, guess what? He walks into that termination meeting and says, oh, by the way, you know, or whatever. He calls OSHA on his way into the meeting. Okay, or he tells the supervisor who's responsible for safety that this stuff is going on. All of a sudden, they can potentially protect themselves under that. So just be careful with that kind of stuff. The whistleblower protections are getting really a lot of attention. They keep expanding them. You used to have to actually call the enforcement agency and lodge a complaint. Okay, you don't need to do that anymore. You need to tell someone in the company who has authority and ability to change that practice or procedure or report it or address it. Okay, you don't actually have to go to, you know, OSHA or the Labor Commissioner or the DFEH or anybody. You just have to tell somebody in a position of authority. So that's a scary one. On page 31, you know, peer reviews can be enough to create adverse action or against a whistleblower. So somebody blows the whistle and they don't demote them, they don't cut their pay, they don't do anything. But when the evaluation comes along, the person they blew the whistle on is allowed to put feedback into that review. That was enough to constitute adverse action. Okay, so you just be very, very careful. Actually, page 32, this is probably the best example of that. That's Yao v. Santa Margarita, or Santa Maria, no, Santa Margarita. So he says they're doing fraudulent warranty claims. And they look into it, and oh my gosh, they are. And then they look at all the claims, and guess what? He's the one who signed off on all of them. So they fire him for participating in the fraud that he reported. Okay, and the court said, well, wait, he's protected, he's protected. Okay, he blew the whistle, and they said, you know, it might have been, you know, reluctant participation. So we need to let this case go forward. And, you know, it's not, we can't just dismiss it in and of itself. So it's just very, very crazy in terms of that kind of stuff. If you've got somebody who's reporting whistleblower stuff, and remember, you know, if they come to a supervisor or somebody in a position of authority, that's where that training is really critical. That information absolutely has to make its way up the food chain, okay, so that we know we can, A, address a situation and make sure we take proper steps, okay? I'm going to skip through the rest of this because we're almost out of time. Page 34, Allen v. Chanel. This actually might be my favorite case of the whole year. Just such a clever plaintiff. She files a harassment and discrimination claim. They come to an agreement. Okay, we're going to pay you a severance. You're going to sign off on this release. This is pretty standard how these things settle. And the release says, in order for you to get this severance payment that we're about to pay you, you need to sign that you're not going to sue us for harassment, discrimination, any of the stuff that happened while you were employed. Okay, great. I think it was like $80,000 or something she was going to get. So they send her the release. Great. She looks it over. Okay, and in the release is this standard language. Plaintiff, releases the employer from liability for all claims, including harassment, Title VII, FEHA, blah, 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 all this stuff. She takes that document, makes one change. She changes including to excluding. Okay, and the font of that document, if you measure the IN width versus the EX width, they're the same width. So if you were to take the document, and hold it up to the light, every single letter and word would match. That nothing changed except for, in the middle of this paragraph, there's these two letters that are different. Okay, and so the document comes back to the company. They go, okay, yeah, good, okay, looks sound great. Pay her severance pay, and then go about their business. 3 months later, she files her lawsuit, and they say, what? No, you signed this release, honey. Yeah, sorry, you're out of luck. And she says, oh, no. It says excluding these claims. So these are the claims that I'm going to go ahead and bring. And then the employer said, look, this is fraud. This was, not fair. And they said, sorry, she gave it to you. You had an opportunity to read it. It's not, it's not our fault. You paid her the severance. They found that in changing those letters, they didn't think it was deceptive, which I think it really was, but they said she was evidencing an intent to preserve those claims, and she gave it to them. I think, she was just representing herself, and they had a whole team of lawyers on the other side, and, the court said, sorry, you didn't read it. Anyway, yeah, amazing, clever. So yeah, read the documents that you get. How about that? That's your absolute takeaway. What? Yeah, work for Chanel. Yeah. Against this big company. I mean, I always root for the company, but in that one, I was like, really? They didn't even. Yeah. I know. Well, the other takeaway in this: send your documents out as a PDF. Okay, don't send your documents out. So that they can't. Yeah, change them. That's what I do. But on page 36, I just want to touch on arbitration agreements a little bit because we had a big case last year, Iskanian. This is the one. Can you waive a class action, your right to bring a class action in an arbitration agreement? And that was an open-ended question, went up to the California Supreme Court, and we have a real fight. The federal courts are saying, you absolutely enforce these arbitration agreements. They're valid. We enforce them. Federal law preempts state law. Yay, arbitration agreements. Okay? And on the state side, we have, no, we won't enforce it. That's invalid. No, it's unconscionable, with this total animosity towards arbitration agreements. So this case comes up, and it's kind of a bridge between both of those worlds. The court said you can have a provision in your arbitration agreement that says, I will not bring a class action. I will only sue on my individual behalf. I'm not going to bring a whatever. I'm not going to be part of a class action. I can only bring claims that happen from me personally. And that's enforceable, great. I mean, as long as the rest of the arbitration agreement is enforceable, that's not in and of itself going to, throw the agreement out. You can't also waive what we call Private Attorney General Act claims, PAGA claims. Okay, and PAGA claims are the employee sues on behalf of other employees, okay, and they can recover penalties. So there's still some exposure. You can't get rid of everything with an arbitration agreement, but PAGA is far less dangerous than a class action. Okay, the statute of limitations is smaller. You only recover penalties. A percentage of those penalties go to the state, so the plaintiff's lawyer isn't going to get all that money. So there's exposure, but it's down here as opposed to up here. I would certainly encourage you to have an arbitration agreement if you don't have one. Okay, you can have it as part of your handbook. That's a little bit riskier. It's better, I think, to have it as a separate standalone agreement. But the courts have said an arbitration agreement, just because it's in a handbook, that is not grounds to negate it or render it unenforceable. So they really, if you can cut off the ability for somebody to bring a class action against you, that's huge. That's a tremendous amount of liability you can shield yourself from. Okay, so it's certainly worth thinking about. Actually, the bullet at the top, Carmona, if you do have an arbitration agreement, okay, and if you have Spanish speakers in your employment, okay, translate it. Make sure it's fully translated for them. They did not enforce that arbitration agreement because it was only partially translated. And that's kind of counter to contract law in general. That's why they tell you read everything before you sign it. Typically, if you sign something, you don't get to come back and say, oh, shucks, I didn't understand what I was writing. I didn't read it and I didn't understand it. Too bad, you signed it. Okay? And that's what the employer tried to argue here. And they said, well, no, not with arbitration agreements. We're not going to do that with an arbitration agreement. They give up too much of a right. So be careful with that one. The last one I want to talk about is, I think, on the last page. I'm in the miscellaneous issues. Okay, and this is Perez v. Shippers Transport. And the thing I just want to flag for you here, so a claim comes in, there's going to be a lawsuit potentially, and the employer does not do what we call litigation hold. They don't preserve all those documents. It wasn't they were actively destroying stuff, but they had a computer system, that does an auto purge after 90 days or 30 days or whatever. And it clears out the voicemail, clears out the email, and that's what was in place. So when they go forward to do discovery, all of a sudden, we've lost all the emails that the, alleged harasser sent or whatever. Okay? And what the court did, they gave an adverse inference jury instruction, and that's a pretty, bad instruction. Okay? It basically says, look, they knew there was a lawsuit going on, and all these documents got destroyed, and so you can go ahead and presume that they were really bad. Okay, that's really scary when you're trying to defend your claim, and you got a jury that can infer that, oh, well, maybe it said, X, Y, and Z. So be very careful. If you end up with a claim, okay, and hopefully you won't, but if you do, make sure you put a hold on that stuff. Okay, get that phone. It's easier to keep that in mind with the emails and the voicemails and things like that, but text messages are the other one, and that's sort of the forgotten piece, where you've got people texting back and forth, and oh, shucks, they deleted all their texts. Okay, once that claim comes in, we need to preserve all that evidence. All right, so we don't get in trouble. Okay, well, good. I finished with 5 minutes left. Are there questions? Sorry, it's a lot of bad news. Yes. I'm going to rename this. Yeah, the 101 reasons why you don't want to do business in California. There you go. Well, yeah, eventually there won't be any employers left. Okay, if you don't mind, please fill out that evaluation form, and I'll stick around afterward. But thank you.